Hello friends, and welcome to this lecture on civil liberties. Civil liberties are very much at the heart of the American political tradition and any study of American government. Therefore, we have to take them with a great deal of seriousness because they're one of the most enduring, one of the most celebrated parts of American politics. Well, what were the founders' views? Let's talk a little bit about their sort of original views of liberty by the founding generation and really the politics of civil liberties. The objectives of the founders were pretty clear. They thought government should be limited, that it should not be the majority role or dictate one's life. Liberty, as we talked about in the Declaration of Independence and in early uh, documents, state constitutions, even in the British tradition of uh, the British Bill of Rights, the Magna Carta, John Locke, Edmund Burke, all these thinkers that we discussed in the early part of the semester, liberty really translated as the lack of coercion. And that's why the founders, when they're asked, what do you want um, from England? We want the rights of England, our rights of Englishmen, the rights we've inherited as English citizens. The Constitution is a list of really protections from the government. If you look at the Declaration, the Articles of Confederation, and the Constitution of 1787, they're all defenses of the citizen and the citizen's liberty from government. If you look at the Bill of Rights that's adopted in the first Congress, and we consider it part of the original Constitution, although as we know in our study of the Constitution, it comes later, it's basically prohibitions against government doing certain things and having influence or too much influence in citizens' lives. So, in essence, liberty is the lack of coercion, and liberty related to individual citizens. The Bill of Rights originally did not apply to individual states, but only to the federal government. So keep that in mind. Okay, let's talk about politics and culture and civil liberties. Um, we should begin by saying and acknowledging up front that liberty or civil liberties have become a major issue in American life, American culture, American society, and liberty, civil liberties are something that's very much abused, very much on one hand taken for granted, and in another way stretched beyond any kind of rational, logical argument for what should be a liberty and part of our overall civil liberties. The Harvard law professor, Mary Ann Glendon, for example, wrote a book called Rights Talk that everybody tries to defend some action that they want to do, some action that they want government to take, or some interest group to take, or some entity to take on their behalf or behalf of people they're associated with. They call it a right. And that we've got a right to almost everything. I kind of dismissed that to a number of years ago when I was teaching this class, and some wild character in the back of the class raised his hand. He said, "Hey, Cheek, we're talking about rights. I think I have a right to party." Well, we don't have a right to party, but he was certainly engaging in rights talk and pretty excited about making that claim. Um, I'm not sure how he's ended up in life, but I pray he's well, and he's probably claiming less rights for himself than he did those years ago. Sometimes rights are in conflict. The Bill of Rights itself contains some conflicts. Um, just to give you a few quick examples to think about, and these are cases that made it to the Supreme Court, and having that we just studied the Supreme Court, these are issues that you will know and be very comfortable with. One of those is the Shepard case, which was really a free press versus a fair trial. Also, there's when involving the press, again, the New York Times case and the Pentagon Papers case that claimed that while these documents were not properly transmitted to the people who published them, the New York Times, is that the welfare of the American people depended upon knowing that information. There are a number of speech cases about what kind of speech, and we're going to talk about that in a moment, is allowed and not allowed. There are a number of famous Supreme Court case, Kurtz, involved some anti-Jewish speeches. And then is the idea of free speech freedom to say anything? Or are there limitations? And then what should those limitations be? Struggles over this have many interests and interest groups that promote one side of a perceived right against another. Also, we have to admit, in terms of politics and culture and civil liberties, that we have some cultural differences in America. America was originally settled by white European Protestants who had a certain view of life, certain view of politics. But over time, especially in the 20th century, and even in the 19th century, even at the founding, America has been the land of the free, the beacon of light for the rest of the world, at least in our self-perception. And so immigrants have come to the United States with great regularity. For example, as a Christian nation in many regards, or at least in the minds of many Americans, when you have the immigration of non-Christian peoples, they may have different views. One of the controversies that has made its way to the Supreme Court in recent years has been government-sponsored creches or religious displays at Christmas. These are, of course, tied to the Christian religion. Non-Christian groups have brought lawsuits against cities which are not churches, but are to represent all the people in theory. They brought legal cases against them in some cases. On the other hand, those who believe that America is strongest when it is united by its cultural patterns, for example, the speaking of English, have promoted the idea that English should be the official required language of all Americans. Again, other groups argue against that. The Boy Scouts of America, probably the most prominent youth organization in America for a century, prohibited gay individuals from leading groups of boys called troops. They're the organization of scout troops. This recently changed, but it gives you some idea of how there was a cultural conflict over that for many years. Okay, let's talk about one of the central issues with civil liberties. And most of these debates, if you want to refresh your knowledge and your thinking about them, go back to the Constitution and look at the first 10 amendments, and particularly the First Amendment that contains most of these issues. Remember, it was the anti-federalists who claimed that we needed a Bill of Rights to protect our liberties, and indeed they were correct. It's also correct to suggest, as the Federalists did, that there would be controversies related to a Bill of Rights, and that the Bill of Rights were already in the Constitution. Well, that's a great debate for discussion. Let's talk about interpreting the First Amendment. Free speech, or think about it in terms of free speech and national security. According to the great English 17th century legal thinker Blackstone, is that the press did not have to, the media did not have to tell government in whatever form about articles it was producing, and the press could not be censored or prevented by government from producing a particular news story or a piece of information, or we think of it in the 20th century and 21st centuries as a television broadcast, or potentially even a digital internet-based presentation. Although that idea of prior restraint, the government has the power to prevent media in any form from producing an article or a story, has been deeply debated in American life. Um, and one example from when I was in college in 1979, a far left magazine called The Progressive was promising to publish an article on how to build a nuclear bomb. They were going to dedicate the whole issue. And apparently, it's not very complex in terms of if you're a chemist or somebody, a physicist, and you're sort of fumbling through graduate school, you still have enough knowledge that you can build some type of nuclear device. Now, as a crazed political scientist, I was not a good candidate, but I got this issue in the mail, and the I was an RA in a dorm, and the dorm supervisor came to me and said, "Cheek, word on the street is you're building a nuclear bomb." I said, "I can't even properly fill up a water balloon, nevertheless make a nuclear bomb. This is just a magazine's article." But the government tried to block the Progressive magazine's article on how to build a nuclear bomb. That was a case of attempted prior restraint that failed. Um, in the early 20th century, Congress tried to limit certain types of speech. The government tried to limit certain types of speech. Um, uh, Speech that was promoting treason, to overthrow the government, or insurrection, attacks on the government. And the court, in a case called the Sneck case, said that if there was a clear and present danger, that they could prevent articles from being published. And that creates kind of a clear and present danger test, although government is very reluctant to block those kinds of articles. Part of this comes back to the 14th Amendment, which we've studied already, and its due process clause that is very controversial. This was not applied to the states, but originally only applied to the national government. That's going to change over time, and it will apply to the states. After World War I, the Supreme Court generally, and it's the sort of decider or arbiter of these issues, it's become more to side on the behalf of free speech. Although there were cases where communists were convicted of gravity of evil speech, or by 1957, if your speech was based upon the idea that you were trying to incite violence against others, it's also a kind of speech. Although the court over time has become to side more with free speech. The most famous within the last half century or so, in 1977, in a famous case, the court held that a Nazi march in Skokie, Illinois could be held and it could be lawful, even though many things they would be arguing and saying in the course of that talk would be against other citizens. And generally speaking, what we call hate speech is permissible, but not hate crimes. So you can say bad things, but if you act on them, you are not protected. These issues are continuing to evolve and will evolve your whole lifetime. Well, what is speech? How do you define speech? How is it? People define it in many ways, but our purpose in this class is, of course, to see how the government defines it and how citizens define it. Some forms of speech are not fully protected. To give you some examples, the first example is what we call libel, L-I-B-E-L. They are written statements. Slander is spoken statements that we'll come back to in a minute. Libel is not protected, and slander is not protected when it is based upon, the court says, malice or an effort to hurt somebody else. And if you do make those kinds of claims, if you do attack people and it hurts them, you may be subject to and if you're convicted of such an effort, you may be fined, or you may get some hard time in jail. There are many examples of this in the last 50 years or so, we'll probably you will see a lot more of these cases in the future because we're a highly litigious society. We've got a lot of lawyers. Where the Japanese have a lawyer for about every 5,000 Japanese, we have a lawyer for about every 450 or 500 Americans. And those lawyers have to do something. They can't just sit around watching Judge Judy or some television show about law. And they've got to go out and sue somebody, represent somebody. And I'm joking for the most part, but we do have a more legally active society. Another type of speech is obscenity. We have many years of decisions of the Supreme Court based upon obscenity. We have a famous 1973 case that suggests if it's obscene to a particular community, then it can be limited in a community. But also, other people can claim for artistic reasons that speech should go forward. Localities basically are allowed to make those kind of decisions. Now, this, of course, is much more complicated in the 21st century and the overwhelmingly challenging influence of the internet, because pornography is available to us all the time in so many varieties, at least as it's reported in the media and the press, that becomes a challenge in itself. Some types of what one person would call obscenity is protected for another person. For example, the Supreme Court has ruled many times that nude dancing is okay, but it's not really protected like some other types of nudity. For example, if you go for purely artistic purposes, if you're in an art class, it's very commonplace to have a nude person allow themselves to be drawn by and painted by the class or whatever. That's a very common way. Zoning allows, that's for states and particularly cities and towns are allowed to make certain rules. The Supreme Court has upheld the prevention of nude dancing in adult facilities, allowed cities and towns to make those kind of decisions. Also, another type of speech that is somewhat controversial is what we call symbolic speech. Acts that convey a political message, flag burning, burning your selective service card. It's generally not protected, although some types of symbolic speech are protected. An example of that would be flag burning. Many times in protests, particularly in the 1960s, you still see it today, some kind of protest, some kind of protest group against the government will burn a flag. So, we don't like America. We don't like what America is doing. We don't like this particular action of government. Well, that's allowed and been protected. Another question fundamental to civil liberties is who is protected? Who is a person? Generally, individuals like you and me are given more rights than corporations, companies, entities, interest groups. Although over time, corporations have been given similar rights to individuals. Regardless of the group, regardless of its political ideas, whether it's a bank in Boston or a bank in Swainsboro or a pro-abortion lobby or an anti-abortion lobby, a California utility company or Georgia Power, they're treated about in the same way that individuals are under the law. Now, especially in terms of the kind of speech that they can make, the kind of public statements they can make. And just as we as individuals are given tremendous amounts of protection in the things that we say and do. Now, when it comes to commercial speech, not the speech of persons, but commercial speech, advertising, it tends to be more restrictive on speech. What companies advertise has to generally be truthful. They have to generally be allowed freedom of speech, but that speech then has to be um, accurate and honest. Unfortunately, as a sort of general tendency, younger people have fewer rights. School newspapers can be restricted. If you live in a dorm, that dorm can be searched much more easily than someone's house can be searched, and that general trend continues. Okay, shifting gears. Another issue related to civil liberties is church and state. In America, as we know, uh, we tend to be a religious people. We tend to value religion. We tend to give religion a great deal of freedom. The First Amendment has part of the First Amendment is the Free Exercise Clause. That's the Free Exercise Clause, which states very directly that government cannot interfere with religious speech. And like speech in general, American citizens, preachers, rabbis, imams, televangelists, not that all those are the same, of course, are given a great deal of freedom to say what they need. The law, especially the First Amendment, does not allow government to place special regulations on religious speech, because that would be, in the eyes of the founders and the ideas of the Constitution, interfering with religious speech. But this also means that religion is given the opportunity to have a special amount of freedom in American life and American politics. But and also given, there are many issues related. Most churches are tax exempt. They don't pay taxes. Again, this idea of religion and politics being different spheres, which we're going to talk about in just a moment. Sometimes religion and churches and state are in conflict. I'll give you a couple examples. One is the idea of the conscientious objector. That's a person whose religious beliefs teach them that war is bad and they have to avoid it at all costs. Many of those people come from what we call the peace churches that come out of the Radical Reformation, that believe it is immoral to serve in the military and that is against their religion to serve in the military. If they are drafted, for example, if we were to have a major conflict, they would be able to, in theory, not serve in a combat setting, serve in some other, perhaps even non-military setting, or even be, in the most radical case, exempted from military service. There are religious denominations that do not allow their members to work on Saturday, which they consider to be the Sabbath, the holy day, and the churches and the court and these churches take that obligation seriously. Though most Christian religions would celebrate the Sabbath on Sunday, there are some Christian-related groups who do this on Saturday, and there are other religious groups. Generally, when there's a special provision, a special need, the court has upheld the religious entities or religious organizations' right to allow their members to live their lives how they want them. Okay, let's talk about another aspect of church and state, the Establishment Clause, which really was promoted by Thomas Jefferson's letter to a group of Baptists in Danbury, Connecticut. And what he said is we need a wall of separation between church and state, that religion and politics should be separate. And so this has become, although it was not part of the Constitution, something Jefferson said in 1947 in an Everson decision. The Supreme Court made that really the law of the land, that religion and politics should be separate spheres. But the Establishment Clause, really all it requires is that the national government does not create a national religion or dictate a national religion. We've got many things that are, we think are official. I mean, I was a Methodist minister. Methodist Church used to think that the Methodist Church was America's religion. It was not. Dallas Cowboys used to think they were America's team. As a football team, they're not. So the effort to create a national allegiance is usually unsuccessful, but especially in religion, where the Constitution says itself there can be no national religion. Government cannot establish that. So this wall of separation is a big issue, one with a lot of contention, and one in which, as you saw, you can see in the textbook and in the readings, a source of ongoing issues in American life. Okay, let's shift gears a little bit and talk about crime and due process as part of civil liberties. One of those key protections from the Bill of Rights, as interpreted by the courts, is something we call the exclusionary rule. Most countries in the world punish police misconduct, with whatever variety it may take, by having a separate trial after a criminal trial. Let's say if police were doing something illegal or inappropriate, for example, trying to trump up charges against someone by putting drugs in their car. In most countries of the world, there would be that particular case, and then there would be a legal case and court process against the law enforcement officer or officers who are throwing the cocaine under the front seat of someone's car just to arrest them. In America, it is more common, while there are typically there's typically punishment for law enforcement. On the other hand, that kind of dishonest action is usually excluded by the courts. Also, if information is obtained inappropriately, it is also excluded. We also, in this same area, the government must get permission to search your car, your residence, and so we have constitutional protections against illegal search and seizure. Government must obtain a warrant, a search warrant, to search your car and your possessions in almost all cases. When can police search a car? When they have a search warrant, when something is in plain view, or when there are other circumstances as well. So government does have the right to search in that area, but you are protected generally by the Constitution against illegal searches and seizures. Also, as it relates to driving, you have the privacy of the home is a very important law. And there is a notion of privacy that has evolved from the courts, and that is very important. Of more recent concerns are related to terrorism and civil liberties. The USA Patriot Act, which was enacted after 9/11, then renewed, gave the government more power to tap phones, created a special court that allowed for the tapping of phones, voicemail seizures of information, and a special juries are actually special hearing boards. Also, it strengthened generally the courts, special courts, like the military courts, be used in particular situations. Most of the 9/11 terrorists who were in Cuba at Guantanamo did not go through American military trials. Did not go through American civil trials. They went to American military trials. So that President Obama, from 2009 to January 2017, tried to change that, and was in some cases that was successful. But strengthening those kind of courts that have kind of fast track courts We live in very exciting times. Our civil liberties are at the heart of what it means to be American and what it means to be part of the American way of life. Ladies and gentlemen, I urge you to continue to study your civil liberties throughout your college career and throughout your lives, because it's very important to who we are from our colonial period, from the founding, even as back as our English tradition to today. These conflicts become more exciting, more interesting, more complex, but still very much at the heart of the way we live our lives. Thank you.